Hi everyone. We received your emails where you were asking us about what an installment sale is and how do you go about it, and a few questions related to the installment sale. We then went out and we spoke to Johan Muller, who is a conveyancer, and he helped us answer those questions. So we are now inviting you to listen to what Johan had to say about the installment sale. So if you are not happy or you still want to know more, please feel free to send us an email and we will make sure that you get the answers that you need. Please do enjoy. Thank you. Good morning, Johan.
Good morning.
Thank you for welcoming us into your space.
My pleasure.
Like I mentioned, today we are going to be talking to Mr. Johan and Johan Muller. And we are going to be talking about a number of topics, but we are going to be talking first about installment sale. Right? Mr. Johan is a conveyancer at Snyman de Jenna. So I may not be pronouncing it right, you will assist me there. And I'm going to be asking him a few questions about what is an installment sale and a number of questions regarding the installment sale. So, Mr. Johan, can you please tell us what is an installment sale?
Olu, thank you very much for the opportunity. You get two types of transactions. The first one being an outright purchase, where a lot of parties enter into an offer to purchase. They then approach a financial institution for purposes of finance to finance the transaction, or they purchase the property cash. But a lot of people are not in a position where they can either qualify for the full finance or they are not in a position to purchase the property outright in cash. So in that regard, the Alienation of Land Act 68 of 1981 in South Africa makes provision for a so-called installment sale, or it's a basic concept of purchasing a property on a monthly down payment scheme. What happens is a lot of foreign nationals that purchase in South Africa are, due to the internal networks and rules of the bank, not able to qualify for more than 50% in the form of mortgage finance. And they don't have the other 50% in cash to put down and facilitate the transaction or the sale. So in that regard, what the parties typically do is they enter into an agreement in terms of which monthly installments are then paid towards the purchase price and not towards rent. So it's not a typical rental transaction, but it's basically a down payment on the purchase price. Now, the parties can enter into a multitude of conditions and terms, such as who pays the rates and taxes, who pays the levies, when occupation is provided, whether occupational rent will be payable additional to the monthly installments. And then what happens is that to provide security to the purchaser, that specific transaction is then endorsed against the title deed of the relevant property to notify the outside world that there is a current installment sale pending on this specific property, and to prevent the seller from then obviously reselling the property during this period of time to someone else. It unfortunately only involves or applies to residential property. It does not apply to agricultural property, and it does not apply to commercial property as such. But it is a good and an alternative to a right-out purchase or a transaction in those specific instances where parties can't afford the full purchase price or qualify for financing.
Okay. And another question also that comes up is what is a prerequisite to an installment sale?
Well, the prerequisite itself is obviously that you have to deal with land that qualifies within the Alienation of Land Act. So it has to be a property that is primarily used for residential purposes, not agricultural, as I said, or commercial. And then you would have to have the parties involved and the contract looks different than that of a normal or standard offer to purchase. It obviously has to be very specific with regards to the terms and the conditions and what obligations and rights the parties have during this specific period of time, such as what the monthly installment is going to be, what additional costs the purchaser will be liable for, what the frequency of payments are, the time frame for purposes of the down payment. And then what's important as well is that Section 27 of the Act does provide for the fact that if you have procured 50% of the relevant purchase price, in other words, you've already down paid 50%, then in that regard, you can demand transfer of the property into your name by performing and paying the balance. So that normally then eases up the process for foreign nationals, for example, that have already now down paid 50%, and they can now qualify for the balance of 50% with a mortgage bond. And then we register the mortgage bond simultaneously and do the transfer of the relevant property into the name of the purchaser.
Okay. And then who drafts this agreement? Who gets to select the attorney? Is it the buyer or the seller?
Under normal circumstances, just as in a normal offer to purchase, the seller has the prerogative to nominate the relevant attorney because the attorney, although he would draft the alienation of land agreement or the installment sale agreement, he will ultimately also reserve himself the right to do the transfer when that specific agreement results in a transfer in future. So normally nominated by the seller, but the costs involved for drafting of the agreement as well as the costs involved in the eventual transfer is for the account of the purchaser.
Okay. And then everything has its advantages and disadvantages. Can you tell us the advantages then of installment sale?
Well, I think the advantages are quite self-explanatory in the sense that parties don't have to qualify for a full mortgage loan or the purchase price right up front. There is an installment sale, so a lot of people can afford monthly installments as they can afford normal rental, but they cannot necessarily qualify for the lump sum in the form of a mortgage bond. So it obviously extends the period of performance, and it provides all the other advantages of normal ownership, such as possible occupation of the property. So you can utilize the property in the meanwhile as a tenant would. And you can then, in the process, down pay on the purchase price instead of just paying rental, which is normally not, except for occupation, you don't get any other counter value in that regard. So the advantages is definitely an extended period for purposes of performance.
Okay. And then the disadvantages?
Well, the disadvantages, as you can imagine, is that it's riddled with administration. For the period of the down payment, it's very important that parties have to keep very diligent records. Although the attorney would proceed in drafting the agreement, the execution of the agreement and the maintenance of the agreement administratively wise has to be done by the parties themselves. So each and every payment has to be noted, each and every interest payment has to be noted, proof of the relevant consumption accounts and the rates and taxes, if that forms part of the agreement, has to be monitored on a monthly basis to make sure that the purchaser is in full compliance with the relevant agreement. And only when all of those specific obligations have been met, then, it results in a transfer and the transaction can be concluded. So I think the administrative burden involved in it is quite cumbersome. But if the parties obviously, they haven't got a problem and they're diligent in their monthly administration, that would suffice.
And then another question, what happens if somebody, or rather the purchaser, does not keep to the agreement?
Well, that's an interesting question because obviously, like any specific agreement, there has to be provision for the downside of a relevant agreement as such. Section 19 of the relevant act prescribes basically that you have to place a party on terms. Now, in other words, if there's a breach of the agreement by the relevant purchaser, he doesn't make payments or he skips certain responsibilities in terms of the agreement, you've got to place him on terms. In terms of Section 19, you've got to give him 30 days to remedy his breach. In other words, you've got to notify him and say you are in breach of the agreement in that you have not made payment of the agreed upon installment. And if you do not remedy this breach or do the payment within the 30-day period, then the seller has the right to do one of two things. Either he can claim specific performance. So he can approach court to basically enforce this relevant agreement, or he will cancel the relevant agreement. And then the contract pretty much stipulates what happens in the event of penalties. Because normally by then, your purchaser has already procured or paid or even released a certain amount of that relevant amount after the noting of the endorsement in the title deed. And then the contract regulates what happens to it. So it can actually be forfeited in favor of the seller as a pre-negotiated damage, and the contract be cancelled. Or otherwise, like I said, you can approach court and claim a specific performance in terms of which the court then compels you to proceed and comply with the terms and the conditions of the relevant agreement. So there is unfortunately a bit of a downside. The purchaser stands a lot to lose if he does not adequately perform in terms of the agreement. So the advice would be, before you enter into such a type of agreement, you have to be comfortable with your obligations in terms of it, because the failure to comply with those specific obligations would have a possible devastating effect.
So what happens, life, we don't control what happens to us to the future, but what happens if maybe the purchaser in the process passes away?
Well, one has to remember that the law of succession obviously comes into play then, because obviously all assets, rights, obligations then pass on to the executor of the late purchaser. And the specific law of succession has certain prescribed methods and means that they render your estate. So the executor would pretty much climb into the shoes of the purchaser. And the executor of the estate will then be in a position where he would be able to decide whether it is in or to the advantage of the estate of the purchaser to proceed with the installment sale or to proceed with cancellation of the installment sale, bearing in mind that those specific penalties will equally apply as it would if the purchaser would be there in person.
Okay. All right. One last question before I let you go. Do you have any example of an installment sale?
Yes, we frequently do installment sales. Like I said, in those instances where parties choose to accumulate funds to purchase the property and to take formal transfer. In those instances, we get approached by a lot of either estate agents who have clients which they would like to introduce to this method of purchasing. Or we have clients approaching us directly between purchaser and seller, basically telling us that they do not have the funds at this current stage in a lump sum, and they can, for various reasons, not qualify for full finance, and that they choose to proceed with a transaction of this nature. We then draft the necessary agreement based on negotiation between the parties, and we then also see to the endorsement of the relevant agreement against the title deed in the deeds office. For the duration of that relevant agreement, it would then proceed, after which we will normally see to the transfer. So we've been involved in the process from the beginning until the end, until it transpires into a transfer at the end of the day.
Okay, well, thank you so much, Johan, for your time. I'm sure your details will be available on request, or you can actually share them. I'm not sure which one you're comfortable with.
Sure. Yeah. For anyone who's interested in approaching us, not only for installment sales, but for any conveyancing or property-related matters, you're more than welcome. My name is Johan Miller. I'm at the firm Snyman de Jager Attorneys, and we are based in Centurion as well as Menlyn, and we've got a branch in Midstream as well. So we try and widen our footprint as far as possible. You can contact me at our office number, Pretoria code 348-3120, or on my cell 08256 84 888.
Okay. Thank you so much, man, once again.
Only a
Have a
pleasure.
great day.